Hi everyone, my name's Sophie Bowes. I'm a partner in the healthcare team at Hempsons. I mainly do inquests and patient safety, but I also have a side specialism in complex hospital discharges. And I've been doing this webinar for a few years now, and it's always good to see that it remains a popular one. So, just as a bit of an overview about what we're going to be talking about today, um, the topics I'm going to be covering is to start with, we'll have a look at the discharge to assess model, and before we move on to look at organisations' internal discharge policies, some common problem areas, ways you can escalate if patients aren't leaving or you're having other problems relating to the discharge. And then we will have a look at some case studies, which I think are really helpful. And then we will finish by looking at some learning points, and I can take some questions if there are any. So to start with, and it's probably shown by the number of people who are here, really delayed discharges from hospital are a huge problem. They have been for years now. And we've seen over the last, I would say, maybe 5 years or so, that there's been increasing government spending, although it has gone very much up and down. I think we had a period where in around 2021, 2022, where there seemed to be quite a lot of funding being move towards trying to tackle the delays to discharges. It seems to me, perhaps in the last couple of years, that has dropped off a bit, but it still is very much a problem. And we've seen through NHS England, they've produced specific guidance to help tackle it as well. When I looked at some updated figures before doing this presentation, I was able to find some data from January that said at that point there was an average of just under 14,000 patients per day fit for discharge who were still in hospital. And you might think, well, that doesn't sound like a huge number across the whole country, but really it is when you think about how many beds that's taking up, and particularly thinking about things like waiting lists, bed availability in hospitals. That's a lot of patients to have still in a hospital bed that when they don't need to be there. And I was also looking at what the length of delays were and how often it was possible for hospitals to achieve a discharge in a timely manner. And you can see here some data from last month, which shows that a same-day discharge was achieved in 86.3% of cases, which is good. I think that is improved from other years that I've looked at. 13.7%, they managed to get the patient discharged the day after they were fit. And then we can see the smaller percentages for longer delays from a week to 2 weeks, and then 2 to 3 weeks, and then some with an over 3 week delay. We will go on to look at some of the primary reasons for delays like that. So the Nuffield Trust has done some research on what causes delayed discharges and reasons why patients remain in hospital for longer than they should. And these were you can see on the slide, the four main reasons, which were that there's either no plan or further assessments needed. The second is they're awaiting home or community care. The third is awaiting a short-term bed, and the fourth is awaiting a bed in a nursing or care home, and that's on a more long-term basis. However, their research does suggest that the data from this year shows that delays are falling, albeit very slowly. We tend to find that patients who have been in hospital for longer are delayed more by social care delays than those with shorter stays, and that's probably to be expected, really, because you would assume that the patients who have been in hospital longer are likely to have more complex needs and may need more support and rehabilitation when they go back. The patients who are waiting for the longest tend to be those who are waiting to go into nursing care homes, and that is really an availability issue more than anything else. And obviously some of these are within trust control and some are not. And as we go on through this webinar, I will talk a little bit about how we can try to minimise these delays as much as possible. So thinking about NHS guidance around delays, there is a focus on what's called the discharge to assess model. And there's also the NHS England guidance, which was last updated, I believe, in January 2024 is very much focused on cooperation between NHS bodies and local authorities. And that is really because, as we've just touched on, one of the causes of delays is trying to find appropriate support in the community, whether that's support for patients at home or they need to go into a suitable care home or other rehabilitation setting before they're able to go back to home longer term. And that all takes quite a lot of planning. Under the guidance, also there is an increased emphasis on the involvement of carers and family members, obviously only as far as that's appropriate and you have patient consent, but certainly the carers and family members should very much be involved in decision making. Perhaps there was a time where that wasn't quite as prominent, but certainly now under NHS England's guidance, there should definitely be involvement from any carers or family members who are involved in the patient's care. The guidance also talks quite a bit about care transfer hubs, which are an integrated intermediate care team, and they provide a single point of access for patients who are going to be discharged under the discharge to assess pathways 1 to 3, which we will look at in a moment, but they are primarily patients with perhaps the lower care and support needs or no care and support needs on discharge at all. The way that the Care and Transfer Hub is supposed to work is that the team works in a multidisciplinary way to provide wraparound support for the first 72 hours after discharge so that more assessments can take place, with a view to trying to get the long-term care and support sorted out when that patient is out of hospital. So the discharge to assess model is all about removing patients from hospitals and doing those assessments in the community environment so those beds aren't being taken up. Through the care transfer hubs, any reablement, rehabilitation care and things that are needed for the patients will be arranged, and it's delivered free of charge for up to 6 weeks. The hub is also supposed to have close links to GPs and primary care to try and make sure there really is that support network around the patient after they've been discharged. The NHS England guidance also specifically says there's no right to remain in hospital. And we can see that through this quote that I've pulled out, which we can say if a person's preferred care package or placement is not available once they're clinically ready for discharge, an available alternative is that appropriate for their short-term recovery needs should be offered while they await availability of their preferred choice. People do not have the right to remain in an acute or community hospital bed if not clinically indicated, including to wait for their preferred option to become available. And I think when we go on to look at the case studies, we'll see that this is perhaps one of the really key problem areas, is when a patient is not happy with what's being offered, and on that basis refuses to leave hospital, but they are taking up a bed that could be used for somebody else. So as I was talking about here, this talks about a little bit more about the overview of discharge to assess. So there's this focus on getting people home as soon as possible, and the focus is on as soon as a patient is clinically optimised and safe to be discharged, they go home that day. The guidance says that the discharge destination only has to be suitable for the patient's needs at that time. So we're not taking a long-term look at what does that patient need over the next 6 months and which location, which care package is needed longer term. Have we got something suitable in place for the short term while those longer term needs are assessed? But obviously the discharge must still be safe. So we're not sending people home if they don't have the support that they need to be safe when they get back there. So moving on to the next slide. Hopefully my slides cooperate. There we go. So I touched on the pathways of discharge to assess before. So the pathways are 0 through to 3. So the first 3 of those, so the first one is going to be the majority of people, who are those who are discharged from hospital with no additional support required. And under the discharge to assess guidance, that indicates that patients in that category should be discharged within an hour of being identified as fit for discharge. I suspect that that doesn't happen. But as we have seen from the data that we looked at earlier, actually a large percentage of patients who are deemed fit for discharge do end up going home the same day. And as I said, I think there has been some improvement on that from figures that I've looked at in previous years, which is really good to see. Pathway 1 is the next, they say about 45% of patients who will be going back home with a package of care from either health or social care. And that may be a new package or it may be one that's being restarted, but they are back at home. So there we've got around 95% of people over pathways 0 and 1 who are all going to be going back home. And again, with pathway 1, the aim is to be getting patients out as quickly as possible once they are identified as being fit for discharge. Pathway 2 is then those patients who need to go into a short-term setting for whether it's just a short-term recovery, it's for rehabilitation, or it's for further assessment. And that is still with an aim of getting them home eventually, but they're not able to go home at that point. And certainly those patients, they are going to be the patients where you're going to need to be liaising with the local authority and other organisations in advance to make sure that those support needs are there and there is the right setting for that patient. And then finally, pathway 3, they are the patients who are going to be going to bed-based 24-hour care, and that care is going to be required on a long-term basis. As we discussed, it isn't essential to have that long-term location firmed up and identified at the time of discharge, as long as that patient is going somewhere that is safe and appropriate. So if you haven't got a permanent placement that can be used long-term available at the time that patient is fit for discharge, that isn't necessarily a barrier to discharging them as long as you have a safe alternative. Again, with pathway 3, there needs to be close cooperation and working with the local authorities to try and make sure that the care arrangements are in place, and ideally well in advance of discharge. And that's one of the things we're going to have a look at, is what do we need to be doing to prepare for discharge from quite an early point on, really, not once the patient's fit for discharge, but actually well before that as well. So these are just a few additional points that I pulled out of the guidance that I thought were quite useful. So the first of those is, again, with this aim of trying to get patients out on the day that they are fit for discharge, there should be twice daily ward rounds so that patients can be reviewed and they're identified as soon as possible once they are fit for discharge. The assessment for any longer term care can take place in the community. But as I said, you still need to be making sure that the location the patient's being discharged to is still safe and appropriate, even if it's not the long-term location for them. And that will require plenty of planning and also discussions with the local authority and potentially other organisations as well. It's mandatory through the guidance to consult anyone who might be providing care, and it's good practice to consult unpaid carers and family. The last 2 points here just touch on specific categories of patients. So the first of those is patients who may have mental health needs. Certainly if they are under the care of a care coordinator, the care coordinator should be involved, or any relevant mental health teams or clinicians, to make sure that we are treating patients as a whole and taking a holistic view of their needs and making sure that there is that appropriate support from all agencies in place when they leave hospital. And the final point there is any patients who are homeless should be identified at admission, and there needs to be contact with the local authority's homelessness or housing team at that stage. So right from the beginning of when that patient is admitted to hospital, to work out a plan for what's going to happen when they leave. So moving on to thinking about the trust discharge policy or your organisation's discharge policy. So all trusts should have a discharge policy. It should be in writing, and it should be updated at regular intervals. It should really reflect the guidelines that we've just talked about in the discharge to assess model, but there is more that needs to go into it. So the key things that need to be covered in your policy is planning the discharge. So that is right from the beginning when a patient comes into hospital through to when they leave. How does that work? What does it look like? What does staff need to be doing? The policy also needs to include template letters. Template letters are a really good idea because they mean that everyone gets the same information, there's consistency, and patients are given the correct information every time. So we're not relying on somebody producing a letter from scratch each time. It also obviously cuts down on the time spent on producing these letters if there's a template that can easily be used each time. The discharge policy also very importantly needs to include timescales. So what is the expectation in terms of when patients will leave and what are the timescales involved? And the reason that's important is it links into the final bullet point there that I've put in about the escalation process. So the escalation process is absolutely crucial if there is a problem. So all those other points are very important to every discharge case, but the escalation is important when or if something goes wrong. So staff need to understand what they do if a patient isn't discharged on time for whatever reason, and what the policy is for trying to make sure that that discharge does take place. Without that, there is a risk that staff just don't really know what to do. So if a patient doesn't leave, whether that's because they're refusing to leave or something else goes wrong, they're not clear what steps to take next. And then there's a risk of it drifting and the patient remaining in the bed for longer than they need to, which isn't in their interest and nor is it in the trust's interest either. And some of the other risks of not having a policy or that policy not being followed is that, as I said, staff aren't clear about what they're doing, and that wastes time. Patients stay in hospital for longer than they need to. The third point there, and the fourth point as well in that final bullet point, both relate really more to the issues that can arise if you end up in a court environment. So courts are very keen on consistency, and making sure that it is being made clear to the patient what the expectations are, what the timescales are, etc. So having a policy, having these template letters means that we can be really consistent. And if a case does end up in court, a court can see that the trust has been consistent in what the patient's been told and the information they've been given is really clear. Without that, there's a risk of the court being critical of the policy or the process that has been followed. So looking at the key steps that need to go into the policy, the first thing is that discharge planning needs to start from the point when patients are admitted to hospital. Now, clearly, it might not be clear for all patients how long they're going to be in hospital, exactly what their support needs will be, but it certainly needs to be on the radar from the point that they are admitted and it's starting to become clearer about what their needs are going to be. So obviously, if it becomes very clear at the point someone's admitted in the first few days, they're actually going to be there for a really long time. It may not be necessary at that point to start putting in place firm arrangements because they may be out of date by the time they get to being discharged. But certainly for patients who are on a shorter term admission, the planning does need to start really right from the beginning. Certainly if other organisations need to be involved, perhaps for those what we could call the pathway zero patients who are going to be going home, they don't have any care or support needs, they're not going to need any follow-up, they are going to be the more straightforward patients. There's probably not going to be a need to be involving local authorities or any other organisations, but for any other patients who may need support, those links need to be made with the other organisations early on. And you can see there I've also put in about discussions with the patient and also where appropriate family members or advocates. I think that's really important because it gives you an idea of what they are thinking. And I think certainly from my experience, you can get an idea from those early discussions whether you may be running into problems with perhaps patient or family expectations. And it's helpful to have that dialogue started from the beginning so that they are very clear about what you have in mind. And if there is some divergence in expectations, you can start to talk to the family or the patient about that right from the beginning and hopefully resolve it before we get to the point of discharge. Whereas if those discussions only start once you think you've got a plan in place, and you think everything's ready to go and then discover that really it's far from what they were expecting or what they wanted, those discussions then start at that point, and my experience is that they can delay the discharge. So having those discussions early on is a really good idea. Again, liaising with local authorities and other organisations early on as well. And certainly for so I think it's beneficial to hold a meeting early on in the process. Sometimes it's possible to make all the arrangements through emails and things like that, but certainly I think that it is advisable for complex cases to try and have a sit-down meeting, whether that's in person or just over Teams. But I think that that type of collaboration where people are actually talking and there's a dialogue back and forth is useful and tends to be more productive for the more difficult cases. Once you get to the point where the patient is fit to be discharged, there are certainly arrangements in place. You're confident that everything is there and ready to go. The patient needs to be issued with a discharge letter and a date to leave. And you need to make sure there's arrangements in place to move the patient from the hospital to their accommodation if that's necessary on the date of discharge. So, for example, if someone is being discharged to, say, a rehabilitation unit, they can't get there themselves, you need to make sure there's transport available and that's all set up and ready to go. So, I mean, my experience is it is quite unusual for somebody who is fully fit and happy to go home to start objecting to discharge. Generally, I think we find that those pathway zero patients, if we can call them that, tend to hit the point of being discharged and are quite happy to go back home. It tends to be patients who have support packages in place where we seem to have the problems with them perhaps not being happy with what's in place, and we can talk a bit more about that. So here I've put a list of the common problems that we come across when dealing with cases like this. So the first of them is, the accommodation isn't suitable. Now, sometimes it may be the accommodation genuinely isn't suitable. Sometimes it may be that the patient or their family members think it's not suitable. And it's necessary usually before that to go through and explain to the family why the accommodation is suitable. Now, sometimes I have had cases where it appears the accommodation actually isn't suitable at all. So, for example, the example I put on here, a patient in a wheelchair where they've been put into a flat, but actually it turned out there wasn't sufficient room to manoeuvre the wheelchair. So things like that sound very simple, but I think sometimes in the discharge planning, particularly where there's a lot to consider, little things like that sometimes can get overlooked. The second one is about whether the care package is suitable. The third is about whether the patient is really fit for discharge. So sometimes we see that the clinicians are quite happy that someone can go home, but actually the patient or their family member feels that more investigations are needed or something similar to that. The final point I put on here about the common problems is where there isn't actually a problem. So objectively, there isn't a problem with the discharge arrangements at all. Everybody is satisfied that they meet the patient's needs, but the patient and or family member or carer thinks there is a problem. This is the most difficult one to resolve in my experience, because with the other ones, if you've identified that, for example, the accommodation isn't suitable, the care package isn't suitable, or there needs to be something else added to that package, they are generally fairly easy to resolve. And once that's sorted out, the patient can go home. However, if there is a fundamental difference between what the clinical team and potentially the social care team think a patient needs and what the patient or their family think they need, that can be a lot harder to resolve. Generally, my advice is to sit down and try and have a meeting to understand what the concerns are and to explain why the clinical team and the social care team think that the arrangements in place are appropriate. It's really important to try and address each of their concerns. Sometimes that doesn't work, and we will go on to talk a little bit more about what you can do if that doesn't work and the patient is still saying, I'm not going to leave because I'm not happy. Before we just go on to that, I wanted to touch on the issue of discharge and patient capacity. So it's very important to keep this in mind. And I think sometimes, again, it's particularly for patients where there may be a question mark over capacity, it's not entirely clear. Sometimes it can fall by the wayside a little bit. But it's really important to keep capacity in mind because it determines who makes decisions, how potentially the trust can escalate delays to discharges, and also ultimately if the case did have to go to court, where that case would go to court. So if we just thinking about those a little bit more before I move on to the next slide, if a patient lacks capacity, we might be thinking about whether there is a family member who might have lasting power of attorney. They might be making decisions for them. But also, I think it's really important if there is any question mark over capacity, that any capacity assessments are done early on. So if you are thinking, I'm just not 100% sure whether this patient has capacity or not, it is better to get that assessment done as soon as possible, because what we don't want to happen is for all arrangements to be made for discharge, and then, for example, a family member to say, well, I don't think they've got capacity to be making this decision. We're not happy. We don't think that they can agree to go home, and then to be running into problems at that point. So having a capacity assessment early on, it is a really good idea. And in terms of just thinking about the course, and we will go on to talk a little bit more about the court, but if we have patients that don't have capacity, if that's an adult without capacity, we'd be looking at going to the course of protection. And if it was a child, so for example, if you've got a child who's been admitted, and the parents are making decisions about whether they can be discharged or not, we'd be looking at going to the High Court in that case. So thinking about if we are in a situation where the patient has refused to leave, you are satisfied as a trust that all the arrangements that are in place are appropriate, the care package is appropriate, the location the patient's being discharged to is appropriate, but they are saying, I'm not going to leave. That's the point where the escalation policy kicks in straight away. So I think the important thing to say is we're always aiming to avoid any legal action. We don't want to have to start becoming, going down the route of getting solicitors involved and threatening to go to court. So the aim of any escalation policy is to resolve disagreements without resorting to legal action. And certainly I wouldn't ever threaten legal action at this stage as well. It's very much about trying to resolve things through discussions. However, I think once you are implementing the escalation policy, it's important to just keep in mind from an organisational perspective that you may end up going down a legal route, whether that is discussions with solicitors or it is ultimately going to court. So it's really important to be keeping good records about what's being done, when letters have been sent, keeping hold of any correspondence, and just being very mindful about what you are saying to the patient and their family. So if the dispute is around accommodation or support packages, it's likely you're going to need to involve other organisations. And certainly in this point, as I said before, I tend to think for complex cases that meetings are helpful anyway. But certainly I think if we're at the point where patients are disputing a care package, any meetings do need to be sat down. They need to be either face-to-face or via Teams meetings with the other organisations involved to try and get things resolved. Obviously, if there is a genuine issue, or you as a trust or the local authority perhaps think, actually maybe there is something in what the family or the patient is saying, you could consider whether you need to get a second opinion. But I certainly wouldn't say that's something that's necessary in all cases, and particularly if you are very confident in your decision to discharge and the package of care that is in place. I certainly don't think that's something you need to be doing in all cases. It's just something to be thinking about. And I think the final point there is it is worth seeking legal advice. If you have, for example, an initial escalation meeting and you think this really isn't looking good, and the patient doesn't seem to be coming around to our way of thinking, it's worth going and speaking to either your legal team or coming to your external solicitors. So we are often contacted at quite an early stage, and we don't have to do a huge amount at that stage, but I think it can be very useful just to talk through the situation with someone who is external and impartial, and just get a steer for whether you're on the right track. So just checking that you are using that escalation policy in the correct way, you're doing all the right things, you're saying the right things, you've considered everything. For that case, it can just be really useful to get a bit of a steer on the next steps. Like I said, we don't have to stay involved after that. We can just give some of that initial advice. And then if you do need to come back to us at a later date, we already know about the case and we're ready to go. If not, that's great. And if we don't hear from you, we assume it's all resolved and that's great. But certainly I would say that if you are thinking that it's a problem that is going to rumble and it's not going to be resolved easily, earlier is better when it comes to getting some legal advice. So thinking about what the policy should include when we're thinking about escalation. So it needs to include, firstly, a meeting with the patient, and the patient obviously should bring somebody with for support if they want to, and including any external agencies to discuss the patient's concerns and trying to agree a way forward. Like I said, I think certainly where the concerns are about care and accommodation, having the local authority there is really important at the meetings. And I know it can be difficult to get everyone in one place at one time, but we are trying to resolve as much as possible through these meetings. So it does really require everybody who is involved to be there and cooperate with those discussions. The policy then, if that initial meeting is not successful, so you get to the end of there's still a divergence in views. The patient is saying, I'm not going to leave, I'm going to stay here until you change my accommodation, change my care package, whatever it is. And everyone else involved is very clear that that package is appropriate and there is no medical need to change it. At that point, the escalation policy should go on to withdrawing the patient's right to be at the hospital. So I think sometimes this is something that's overlooked, that actually my experience is that often we do get to this point of actually having a meeting, but then at that point, the patient's still digging their heels in and the trust is thinking, well, I don't really know where to go from there. And as part of the trust discharge policy and thinking about those template letters, there can be a letter in there about removing what we call the license to remain on a property. So from a property law perspective, patients don't have any right to be to a bed at an NHS hospital. Their right to remain there is as long as the organisation says they can. So, and obviously this is not usually an issue. Normally, while somebody has clinical needs, they have a bed, and there isn't a problem over them remaining there. But once they are told that they have to leave and they are refusing to leave, it's really important that as a trust you are specifically making it clear to them that they no longer have the right to be there, and that then turns it into, at least for adult patients with capacity, a property issue. Now, that's something we can help with in terms of writing letters and things like that. And I would certainly be saying, if you are getting to the point where you are withdrawing a license to be on the property, you need to be having a legal team involved at that stage, because it's obviously getting more serious. And we would want to check that everything that was in that letter was accurate, and it was appropriate to be issuing it as well. But what's really important as the final point there is that keep following the policy. Even if a patient keeps saying, look, I'm not going to change my mind, I'm not going, just keep working through that policy. And the reason for that is, if we end up in court, the judge will want to see the policy, or may well want to see the policy, and will say, have you followed your own policy? And it also, I think it's helpful for staff to know what they ought to be doing. So don't abandon the policy because you think, or the escalation policy part, because you think the patient's just not going to roll over, they're not going to change their mind. Keep going through the whole process towards the end. And obviously, if you get to the end of issuing the letter telling them to leave and you're withdrawing the license and that makes no difference, we may have to think about other steps at that point. So that takes us on to the next slide, is what do we do if we do get to that point? And here, this is where the capacity point really comes into play, because what we would do for children and adults who lack capacity is very different to what we might consider for patients who have full capacity. So thinking about that first category first, with patients, so these are adult patients with capacity. You don't have any concerns about capacity at all. You're very satisfied. They know what they're doing and the consequences. So the first option is just to get a letter from solicitors. So sometimes we can write and we can explain that we are the trust solicitors. Their right to be on the property of the trust has been withdrawn and they have to leave. As I've said here, the pros of that is it's pretty easy, it's quite cost effective, and sometimes it does have the desired effect. Sometimes just having that, almost a bit of a wake up call of saying, oh gosh, we've got the legal team involved, is enough to make the patient concerned enough that they leave. I think the cons of this is in general, my experience is that if a patient is really, sort of set on, they're not happy with the discharge arrangements and they don't want to go, just getting a letter from us doesn't always make a huge difference. And sometimes it actually can inflame the situation as well. But it is something, as I said, that's worth considering as quite a quick and cost-effective way to start trying to escalate things. The second one is the police. I think this would be quite unusual to go to the police. I mean, I've said here, the pros of this are that it's cost effective, that it doesn't cost anything, and there's no need for staff to get involved. But I think the police are generally very unwilling to get involved in situations like this. There's not really a clear legal basis for it, and obviously they're not overrun with resources themselves. So sending somebody out to try and remove patients from a hospital ward probably isn't top of their agenda. It's also potentially quite disruptive to the patients if you were to have the police coming onto a ward. And I think there is the risk of criticism as well, both probably for the police and also for the trust of removing a patient in this way. I think certainly I wouldn't go down this route again without getting some legal advice, and it's very unusual in my experience, but I put it here because it is technically an option, even if not an attractive one. Another one which probably is used more, and I suspect it's used even more than I realise, is to get the hospital security team involved. So again, this avoids the clinical staff getting involved. It doesn't carry costs, but it is probably quite a disruptive and unpleasant route to go down, to send security in to physically remove a patient. There's obviously also potentially a risk of harm, and any adverse publicity from this. Generally, we would advise that this is quite a high risk strategy. And again, getting some legal advice before you're thinking about getting security involved is a good idea. The final option, which is undoubtedly the most expensive and time consuming, but does tend to give the highest degree of protection and most reassurance to trust, is to go down the court route. So as I touched on before, if we've got an adult who's got capacity and they've been told to leave the bed and they're not leaving the bed, it's a property case. So then we issue what are known as possession proceedings in the High Court. This is very unusual, and we will go on to look at 2 cases where this is what we had to do, or what NHS organisations had to do. But it is extremely unusual to have to go down this route. I think the advantage of this route is because it's not looking at best interest issues. It tends to be a lot more straightforward than perhaps cases that end up in the Court of Protection, or for children in the High Court under the inherent jurisdiction. So because it's purely about property, there doesn't tend to be a discussion about best interest, although the judges will still want to be satisfied that any care package or any accommodation that's been arranged will be appropriate. When we're thinking about adults without capacity and children, we're looking at the Court of Protection or going to the High Court under the inherent jurisdiction. This may be a route that some of you are familiar with, even if not in the context of a difficult discharge, but in terms of medical treatment. And in this scenario, there will be a focus on best interest. You might be asked to provide care plans, and there will be a lot more of a detailed investigation into exactly what the discharge arrangements are. And there's the potential for the official solicitor to become involved. And certainly these types of proceedings can become quite drawn out, although you can get urgent hearings if there is a particular reason why that's necessary. And the courts can also order that someone goes to an interim placement, even if the long-term arrangements haven't been sorted out. But generally, I would say that going down the court route isn't a quick route to resolving the problem. As I said, I think the main advantages of going down the court route is you have the security of a court order. So if a court says someone has to leave, you're not relying on, as I said, the hospital security, for example, removing somebody, and you know that there has been appropriate scrutiny over the decision. In some cases, you can also get an order limiting future attendance at the hospital if you're concerned about the patient coming and having a similar situation again. And there is the potential for recovery of costs. I say that slightly hesitantly because I think it would be quite unusual to be able to recover costs from patients in practice, even if a court orders it. Whether the patient has the means to pay the trust legal costs is an entirely different matter. The disadvantages of this route is it's very expensive, it's very time consuming, and a lot of patients will be unhappy when they know that you are issuing court proceedings. Although, on the other hand, some are actually quite keen to go to court and feel that, it gives them a way to have their views heard by somebody else, and somebody independent is taking an interest. So it can go either way. So I know that has been a bit of a gallop through everything, but the main reason I wanted to get through all of that quite quickly is because the next two cases I think are very helpful from a practical perspective. So I wanted to make sure that we had time to look at them properly. So the first of the cases that I wanted to look at is actually quite a recent case. So this was at the end of last year. And as I said, it's very unusual for these cases to end up in court. So when we do get one that ends up in court, it's actually quite exciting. And I think the judges really do take the time to give reasoned judgments and some helpful guidance to NHS Trust, because it is so rare that they end up in front of a judge. And I think that's what's happened in this case. So this was a case where the patient was medically fit for discharge since April 2023. So it had been about 18 months. A supported living placement had been secured, but the patient wasn't happy with that. They wanted a full residential placement. The medical team were very clear that wasn't clinically necessary and that wasn't going to be on offer. So they reached a wall, because the patient just wasn't going to go without that being put in place. But the medical team were clear it wasn't needed, and social care weren't going to put it in place if it wasn't needed as well. So this was a patient where the hospital involved was satisfied that she had capacity, so they issued possession proceedings in the High Court. And the really useful thing about this is the judge who dealt with the case provided some helpful guidance in the form of a checklist for what hospitals should be thinking about when they're dealing with discharge disputes for adults with capacity. So this is what the judge said, and I think most of this is sort of captured in what I've been talking about so far in terms of the steps you need to take for discharge, the discharge policy and things. But actually, I just think it's really beneficial to have this set out in quite a condensed way, in the way they have in the judgment. And also, this coming from a court, I think, helps give Trust just that extra bit of confidence that they're doing the right thing. And I'll certainly be saying that using this checklist when you are dealing with a difficult discharge case will be really helpful, and then you're doing what the court will expect. And I think it probably goes without saying, but courts who are dealing with similar cases like this in the future will refer back to this case and will refer back to this checklist. So using it internally, it is definitely a good idea. So the first point is, has there been a full and holistic preparation of the patient for discharge? Like I said, this is about, has local and national guidance been followed? Have the local authority been involved? And has all the care been explained to the patients? So this goes back to the discharge to assess model, your internal discharge policy, that collaboration with external agencies, and making sure the patient and their family and carers are involved throughout the process. So the court's going to be looking at that and saying, have you done all of those things? So you need to have been doing that from an early point, and obviously you need to be keeping records and notes to make sure that you can evidence that as well. The second is, have there been all necessary mental capacity assessments of the patient? So this, again, I touched on this earlier and explained that sometimes this is something that can fall by the wayside when you're very busy trying to think about the practical arrangements. But the court has really emphasised in this case it's important to treat that as a standalone issue and really give that attention from the beginning. So thinking about, does the patient have capacity to consent or object to the proposed plans? And making sure if there is any doubt over that, that's resolved early on. The other point that was raised in this case was that the judge was concerned about whether anybody had considered whether the patient had capacity to litigate. So once the proceedings were issued, although they felt she had capacity to consent or object to the plans, the judge was worried that nobody had given appropriate time to whether she had capacity to deal with this in court as well. So that's another thing to think about. And obviously, that's not something you need to be considering from the very beginning when you're thinking about discharge planning. But if it is starting to look like you're going to be going in the direction of court, it's something to keep in mind. Now, obviously, if you are going down that route, you will have solicitors involved by that point. And it's something that they would raise with you, but it's just something to keep in mind as well from your perspective as an organisation. And then the final point was about, has the proportionality of a possession or an injunction been assessed? So what the judge was explaining here is that this should really be a last resort. And I think that goes without saying. I don't think any other organisation would be going to court if they didn't feel there was any other way around it. But the judge emphasised that any organisations need to be trying any lesser alternatives to possession proceedings or getting an injunction. And also thinking about any physical or psychological impacts on the patient of potentially getting a successful order from the court and then being physically removed, and thinking about equality impact assessments and things like that. So he was really going beyond what I think perhaps in previous cases judges had ever really touched on, but starting, I think the main message is thinking about the patient and the process as a whole, and taking that holistic look and making sure really everything is being ticked off. But like I said, I think it's been really useful to have this guidance from a court formalised in this way, so that if we are dealing with a difficult discharge case, we can be making sure that we are considering everything that the court will want to see and will want evidence on. And I thought when I was reading the judgment, I thought that this was quite a helpful section. And really the first part of it where I've underlined the hospital should involve that authority, that touches on what we've talked about before. I think particularly the final section from however is just really useful, because what the court's saying here is if the hospital has involved the local authority and any other organisations, they've followed their policy, they've done everything that they should, and really they've got to a point where there is no agreement, the patient doesn't want to leave, and that's not affected by their mental health or a mental capacity issue. It is open to the trust at that point to evict the patient, and I think that's good. I think that's really the reason I put this in, I thought it was just a really good quote, and just to give you as an organisation that reassurance that even at a judicial level, the courts are recognising that sometimes you get to a point where there is nothing else you can do. You've tried your best to resolve things in a collaborative way, you've tried to reach an agreement, but you just haven't been able to do that, and you do sometimes reach a point where actually all that you can do is to go to court to ask for a patient to be evicted, even if that feels an uncomfortable thing to do. The court did also helpfully set out what they call the defences that might be available to the patient when they are trying to object to any possession claim that might be brought like this. So the first one is about a failure by the hospital to have regard to the provisions under the Care Act. And this is about really the duty of the local authority and the hospital to liaise to make sure that they are meeting their obligations with regards to providing care and support to adult patients. Now, I think if we've got to the point where both the local authority and the hospital have got a care and support package in place, and there's been multiple discussions about that package and everyone's satisfied that it's suitable, it's unlikely that there's going to be a failure of the duties under the Care Act. But I think the judge has put that in really to emphasise how important it is for the organisations involved to take that collaborative approach and really make sure they're taking their duties seriously. The second is a failure by the hospital to follow its own policy. And as I said before, this is why the trust having a discharge policy and having an escalation policy and that being followed right through to the end is really important, because it's been specifically listed as a reason why a patient may be able to defend a claim or an application like this. So making sure that policy has been followed is really important. And then the final point is any breach of the hospital's duty to act in accordance with the European Convention on Human Rights. And that ties quite nicely into the case that we're going to look at next, where there was quite a bit of discussion about human rights and how the competing rights can be balanced. So this next case is now a case that is scarily over 5 years old. So I dealt with this in April 2020, so shortly after the start of the pandemic. It's amazing how quickly time's gone, because it doesn't actually feel that long ago. But this was a patient who had capacity, but she didn't want to leave because she didn't have accommodation in her preferred area, partly due to the pandemic and the need for beds, the trust was particularly keen to try and resolve this quickly. Internal discussions had taken place, there'd been various meetings, etc. And unfortunately, it hadn't been possible to resolve the dispute. So proceedings were issued urgently at the start of April 2020, and there were several hearings in the court. The patient's argument primarily revolved around her human rights, and particularly her rights under Article 3, Article 8, and Article 14 of the Human Rights Act. Ultimately, the arguments were dismissed and the application was granted, and she was ordered to leave the hospital. But as I said, I think that this case is particularly useful just from the human rights element of it and the comments from the judge about that side of things and the arguments run by the patient. So here on this slide, I've put what the judge said, which I won't read out in full for time reasons, because I can see from the clock that I am pushing it with time already. But ultimately, what the court was saying here is that when it comes to human rights, patients have rights to, to their family life, to their private life, etc. But there are circumstances in which hospitals will have to balance those rights of the patient who may be using that bed with other patients as well. So there will be other patients who also obviously have human rights, and there will be human rights considerations for them who need that bed. And it is reasonable for NHS Trust to take the view that, if you like, patient B, I think they're referred to here, has the right to that bed, and on that basis, patient A can be evicted. It doesn't matter that patient A's human rights are interfered with, as long as there is sufficient justification. And this is about a balancing exercise between the rights of one patient versus another. Now, helpfully, what the judge said, and this is under the Article 3 section in the final paragraph of this, the judge said the absence of evidence identifying a specific patients or patients who will be disadvantaged doesn't mean they don't exist. And what the judge meant by this is it's not necessary to identify a specific patient that needs to move into that bed and might be disadvantaged if patient A doesn't move out. It's sufficient to say patient A is fit for discharge and no longer has a need for this bed. We have a patient somewhere who will need this bed and can't move into this bed as a result. And that is sufficient. You don't have to identify the specific patient B to be able to use that argument and be able to carry out that balancing exercise. So in this case, the judge dismissed the human rights arguments on the basis that although the patient's Article 3, Article 8, and Article 14 rights were engaged, it was justified to interfere with them on the basis that there were other patients who had equal rights and needed inpatient treatment. So again, I think this is a really reassuring judgment for any hospitals who are dealing with potentially evicting patients against their will, because it just offers that extra layer of protection, that reassurance that actually it is appropriate, or it can be appropriate if that balancing exercise between the competing rights has been gone through, that actually you can evict a patient from hospital, and it is legal, it's lawful to do that. Now, these cases have obviously gone to court and they've been considered in great detail. And as I've said before, I think certainly the very contentious cases are certainly ones that you want to be getting legal advice from and thinking about going to court. But these two cases are certainly the most recent, with what I would describe as helpful guidance for NHS trusts when it comes to evicting patients when you have reached the point where there's nothing else you can do internally to try and resolve a dispute. So moving on to my final slide, which is just, I wanted to try and pull together some of the key learning points, which are firstly is to start planning for the discharge and identifying potential problems early on, and start involving other agencies, the local authority, any mental health trusts, anyone else who might need to be involved in providing a comprehensive care and support package to that patient. make sure you're following your own discharge and escalation policy. That is with the aim of trying to resolve any disputes amicably, and thinking about having meetings in any other ways you might be able to resolve the disagreement. But ultimately, if you are struggling to resolve a disagreement over discharge, seeking legal advice early is a really good idea, and court is there as a last resort. Obviously, if you do need to go to court, it's really important to be keeping in mind that you need to have evidence that you have been through your policy, you have been carrying out all the relevant assessments, you've thought about things like capacity, the impact on the patient, etc., so that documentation is all there and ready to go. As I said, if it's always a good idea, if you think that a case is going to become contentious, to get some advice early on, even if it's just a 10-15 minute chat with a solicitor or with your in-house legal team, just to get an external view on whether you're doing the right things, and just to see whether somebody else who is a bit more removed from the situation can offer any advice on perhaps alternatives you might want to consider to try and resolve things, without having to escalate to either getting solicitors writing to the patient or ultimately going to court. I'm very happy to take any questions, or if anyone's got any comments, anything they want to share. I think one thing I always encourage people to do, if you do have anything you want to share just from your experience of dealing with cases like this, that can be really valuable. Obviously, I see things from a legal perspective, and we only see the cases once they have got difficult and there is a problem. But obviously, I'm always very conscious that actually it's you're on the ground, you're the people who are dealing with this day to day. And if you think you've got any helpful comments or learning from your experiences to share with other people, then it's always helpful for me to hear that, and I'm sure it will be for other people as well.
If everything has been done for the patient with involvement of multiple agencies and the patient refuses discharge on the basis of wanting a better accommodation, a situation of discharge to assess situation, the patient then plays the suicide card if discharged. How can this be managed? Should the patient be allowed to stay in hospital until accommodation they are happy with is arranged by the council? Of course, we don't know how long this can take.
Yeah, of course. So I think obviously it's very difficult to manage. Certainly, I think if a patient's obviously suggesting they're going to harm themselves in some way, it's something that needs to be taken seriously. And I think that obviously would need to be consideration of whether that is something that needs to be explored through getting, for example, a mental health team involved and needing to have some sort of formal assessment. But ultimately, if the question is whether a patient who has mental health needs and whether they maybe have thoughts of suicide or self-harm, whether that ultimately means that you have to provide whatever accommodation they want. I think the answer to that is no. But it is obviously a difficult situation to manage, and it needs to be one that is handled carefully. It's certainly one that I would be saying, if you're in that situation, that's definitely going to your either internal legal team or external solicitors for, just to make sure that you are doing all the right things, you are getting the right assessments, and making sure that the support that the patient needs can be put in place. So it may be that you do need to get a mental health team involved, and it may be that they need to provide support on discharge. But ultimately, obviously, from a social care perspective, what accommodation or care package is offered is based on the patient's clinical needs and their social care needs. So as long as the mental health side of things has been taken into account, it doesn't necessarily change the accommodation decision. But as I said, I think it is really important to make sure that any extra support from the mental health side of things is there. And like I said, it's a tricky one. It is a situation that has come up before and I've dealt with, and definitely needs to be dealt with on a case by case basis.
Our next question: as part of CHC that commissions care, I have a patient that is medically ready for discharge from hospital. Hospital have requested increase in care at home. Care provider can do this. The family and patient are happy with the plan, but the commissioners are objecting and saying needs to be a residential placement. Where do we go? Best interest, medical request, community support, patient, family and care team all identify for the patient to go home.
Yeah, I mean, that sounds quite odd that when there is sort of full agreement from everybody else that there's then obviously they're digging their heels, and I would say that I think that's fairly well. I'm sure I'll be corrected if it's not, but that sounds fairly unusual. It's not something that I would regularly come across. I mean, I don't know what you've done in terms of meetings and things like that, but I think certainly making sure that the commissioners have been sent in writing all the information, full explanation of why this is necessary, why it is clinically indicated, and obviously explaining that all the other organisations involved are in agreement is really important, and potentially trying to arrange a meeting as well. I think after that, you probably are going down, maybe getting some legal advice and going down that route to have a look. Because I think, as I said, that sounds quite unusual and quite strange. I can't really understand the logic there. So I think having someone looking through everything and potentially thinking about writing to them on a more formal basis could be a good idea there.
The questioner actually has her hand up. Lynn, would you like to unmute yourself, please?
Yeah, hiya. I just wanted to add a little bit of context into that one, because I can appreciate I tried to sort of very much caption it and keep it quite short. Basically, the lady is currently in hospital. Everyone is in agreement. I'm currently trying to put the request through to approve the funding for her to come home. But so when I said our commissioning, it's actually our CAP panel, so care assurance panel, that are sort of basically saying that for a cost purpose, we would need to consider a residential placement. We've already considered that, and it's just not a viable option. This lady is extremely complex. Obviously, because she's got CHC, she is complex anyway, but she is extremely complex with her needs. And I can see that if we did try and go down the care home route, it's just not going to be a success. She's going to end up essentially stopping engaging, and she's going to deteriorate massively and pass away.
Yeah, it sounds very difficult, Lynn, and like I say, it's hard to see why there is resistance if that's the case, and all the evidence has been presented to them to show that that is the case as well. Like I said, that may be one where you want to have, I think, a bit more of a detailed chat with either your legal team internally or with the solicitor, just to talk through the details a bit more, so someone can try and understand a little bit more why they may be so resistant to it. Because on the face of it, it sounds like you've got a good case, if I can call it that, for the sort of enhanced package. So it's strange that they seem so keen on not granting that. So I think, like I said, I think it may be something you need to talk to someone about in a little bit more detail, and to think about perhaps what you can do to try and escalate that, and really emphasize what this patient's needs are, and why what they're suggesting is likely to fail.
Okay, thank you.
Can I ask about a patient who's being discharged, but housing provider does not feel the accommodation is suitable, not enough room to manoeuvre hoist on the second floor with no lift, and the patient is bedbound?
I would be saying that if that's what the housing provider is saying, that needs to be taken seriously. And it sounds from that information like the accommodation isn't suitable. So I would be going back and saying you need to be looking for alternative accommodation.
The comment here, one of the main problems in delayed discharges is that local authorities won't accept referrals early, even when issues have been identified due to complex discharge.
Right, okay. I mean, like I said before, this is why it is helpful for me to hear from everybody on the ground, because obviously we see the legal side of things and we read all the guidance and what's meant to happen. And certainly my understanding is that the local authorities are supposed to be, really engaging, particularly with those complex cases from early on. So it's, I suppose when I'm telling NHS Trust that that's what they all need to be doing, and it sounds like it's not always happening on the ground, it's, that's useful for me to know. But I can see that from your perspective, that's not very helpful if you're trying to make sure that everything's in place to discharge a complex patient.
Somebody saying, in our trust, we are obliged to give a choice of 2, often 3 care homes to patients, both private and social services funded care. Where would this guidance have come from, do you know, given how pushed we are for beds and cost savings?
No, I don't have any idea, is my honest answer, because I don't think I've come across that before. No, I generally, my experience is that they're given one option. And I suppose sometimes it may be that there are a couple of options, and if they're both equally suitable and equally available, the patient may be given a choice. But I don't think I've ever come across a policy where patients have to be given a choice of more than one.
In maternity, we are seeing an increase in women who refuse to leave hospital following birth as they want housing, often in certain areas, or better housing. Sometimes these women have no recourse to public funds. This appears to be a growing issue within maternity services, and our trust is currently developing guidance specifically for maternity. However, it's often difficult to get any agencies involved until the eviction process is commenced.
Right, okay. I've not heard about, haven't heard about that specifically, but it does, yeah, that sounds like a particularly difficult situation to be managing, particularly if you've got a mum with a newborn. And yeah, I mean, like I said, it's not something that's come on my radar before, so I haven't given it any particular thought. But certainly, if that is something that you want some more support with, please do get in touch. That's certainly something I can, have a look into and think about a little bit more, because yeah, it sounds like as I said, that's not one that's been raised. I can certainly ask around my colleagues and see if anyone else has come across that. But
we're in Manchester currently, but
okay.
it does happen within Greater Manchester as a whole, but in meetings with other safeguarding midwives across the UK, it seems to be a growing issue across the UK as well. It's further compounded by, at one point, we had a newborn baby who hadn't actually left hospital until they were about 33, 34 days of age. So really complex. We obviously can't just evict mum with the baby, and the local authorities are saying that they will only become involved at the point of eviction and then accommodate the baby. So it's really complex and not a position we want maternity services to be in and having to deal with.
No, that sounds really difficult. And have there been sort of separate? I mean, I suppose what I'd be saying there is, and I'm sure I'm probably making an obvious point here, but have there been discussions with the local authority, sort of outside the context of specific patients, so more in general about, look, this is a problem we're seeing arising, how can we work together to resolve this?
Yeah, that's what we're escalating currently through our integrated care boards.
I think that's what I'd be saying. So I think this is something, I mean, like I said, it's actually not that's why these types of webinars and having everyone here is really useful for me, because I've not heard about this as a specific problem before, but it does sound really, really difficult. And I think what I'd be saying is, it sounds like it needs to be escalated to someone, senior within the local authorities, to try and put together some sort of collaborative working arrangement, because it needs the involvement of both sides, doesn't it? You can't sort it out without the local authority, and exactly. It's not straightforward either, so you need them involved really right from the beginning. So I think trying to agree some sort of collaborative working arrangement that can apply to every case is the best way to go around it. So I think certainly escalating it sounds like a good plan.
Okay, thanks so much.
How do you manage a situation when the local authority declines package of care for patients because the criteria is not met, and the ICB decline support because it is not a nursing need? The patient prognosis is 6 months and will decline in the near future.
I'd say this is definitely a sit down, face-to-face meeting type case, to make sure that everybody is on the same page about what the patient needs, and where everyone is coming from. I mean, I think it's quite difficult just from that information there to say what's going on, or if anybody's in the wrong and the right. But I think it is one that would need to be looked at in a bit more detail. But I'd say certainly sitting down for a meeting with the local authority to try and make sure that all the organisations involved are sharing their perspective, and seeing whether there's any agreement or way around it, something that can be arranged, is a good starting point there.
Thank you very much indeed for attending this morning.